we finished the last session by looking at the practitioner perspective on the debt relief notice. And thanks very much to Tom Murray, who really is one of the leading accountants who has been looking and analysing this area for a very long time. And it will be very interesting to hear how he identifies how the PIPs are going to work. So, Tom Friel.
Okay, thank you very much,
Tom
Nolan.
Murray, sorry, from Friel, Stafford.
No, that's okay. Thank you very much, Nolan. And once again, I'd like to thank you and Paul for extending the invitation to me to join you here this evening. I suppose really being the last speaker, it's very hard to keep everybody interested. So I decided rather than go into the mechanics of the various schemes of arrangements, I talk about some of the issues that as a practitioner that I'm facing getting ready for this new legislation to be implemented, and how I see it's going to affect us as a profession, but also then some of the issues that I'm going to see that are going to face individuals who are looking at engaging a PIP and I'm glad they changed the name from a PIT as you referred to, but because there'll be enough people out there calling us names without the Minister doing it, but certainly to see how we can engage and some of the issues that I'm going to see as we engage with people down to it. I'm going to try and talk for about 20 minutes, give you time for questions, and then get us time to get home, hopefully slightly after the main traffic, but in time to get home and see a bit of telly or whatever. I suppose any debt resolution process, there's 4 key areas to it. You have to deal with the legislation itself, and there's plenty of people talking about that. You have to deal with the courts, I don't propose to get into the courts today. There's also the culture, and I will comment on the culture that's out there and the culture that we need for this to succeed. And then there's also the 4th pillar of this process, and that is the practitioner. And obviously I have a vested interest in the practitioner. But one thing that I'm very comforted by and is the fact that this legislation requires a certain level of competency and standard across the board for the practitioners. And I say this as somebody, and I suppose I should say by way of background, my firm, my own background is that as an insolvency practitioner, we specialise in insolvency, and over the last number of years, obviously that has been focused on the corporate side. But if we look at the corporate side, it has largely been a situation where anybody can become an insolvency practitioner. Okay? There's no educational, no legal requirements needed for somebody to become an insolvency practitioner. And as such, that has led to a mix in the standards of the quality of the work that's been carried out. And it's crucial, and it's one thing dealing with companies, but when you're dealing with families, with individuals who have, as we mentioned, the whole issue of psychology of debt, who have serious mental issues arising from the problems that they're facing, you need to have competent people dealing with it. You need to have competent people from the individual's perspective, and also from the perspective of the creditors who are facing existential debts. So it's very positive to say that the role of the practitioner, there is a standard that has to be obtained by the individual who is taking on the role. I suppose the first thing to say is, and I had a blank slide, but the guys, they've cut it out, but it was deliberately blank, okay? And it was deliberately blank for a reason, is that I'm here to talk about the PIP's perspective, but I'm not a PIP. There are no PIPs as we speak today, because we're going through a process to qualify people to become PIPs. It is anticipated that we'll have PIPs in the next, certainly within the month, that there will be accountants qualified. The Law Society ran a course a few weeks ago. The accountancy bodies are doing it this week and next week and the week after. There's a number of courses running, and likewise the other professional bodies. But I believe, as we stand here today, there is nobody authorised to be a PIP. So it's a little bit wrong of me to come up here and give you a PIP's perspective, but as a wannabe PIP, if I want to admit to me that, this is what I see are the issues that are out there. I'm also going to share what I consider to be some of my concerns, and I do have concerns about the legislation. I do have concerns about the implementation of it, but it is what it is, and we have to deal with it. It's not perfect, and I think, in fairness to Lorcan O'Connor, and I have to say this, when we compare it, and people keep referring to what's going on in the UK, they have a situation that has evolved nearly 30 years in the making. Lorcan and his team started, and he only started putting his team together last November, to be where we are and to have what we have in such a short period of time. He must be complimented. But it will have to continuously evolve, and I've no doubt it will continue to evolve. But we are dealing with something that is in the practical implementation of it has only really been going on for 6 or 7 months. For me, as a practitioner, as an accountant, as for want of a better way of putting it, an experienced insolvency practitioner, there is a whole new environment out there that we have to look at, both legislatively. The marketplace, is this a business I want to get into? Okay, is this an area that I have people working for me, family who have their own families, is this a business that I can contribute to, that I can run successfully, that I can give a proper service at a commercial value. So there's commercial issues. And then I have to look at my own businesses to see, is it a business that we can enter into? And while there's a lot of talk about the fees that you have to pay to a PIP, those fees are driven by the need to run. PIPs are a business, and that has to be remembered. There's also, what we're going to see is there's going to be a lot of unknowns out there, as in the interpretation of the regulations, the various schemes, how they're going to be implemented, and indeed the attitude of creditors, which is something that has been touched on today, particularly in the light of the major creditors that are out there in terms of the financial institutions, and something that I'm going to come back to later on in my presentation. And of course, the joy of being the last speaker is there is no time constraint. I can go on, okay? So not only doesn't have to be giving me any nods or winks.
Never has been at something that I've shared before.
Or had David Hall in the audience either. So it could be here for a while.
I'm only here because you're speaking last.
Yeah. At the end, the last time I heard David, where I had made a speech with David was my wedding, and that was a long, long time ago. And I won't tell you the ructions he caused in the bar, but that's another story. But the fact of the matter, the last point in this slide is we have to work with the legislation. It is what it is. Some of us may not privately agree with all of it, but as a PIP, as a professional, we have to work with what we have, okay? And we have to work to the best of our abilities to bring something forward for the individuals themselves, and also for who are entering it, and also for the creditors. And this is crucial, because the reality of it is, if we don't do it right, the whole thing, we're then probably, with all lack of ego, the most important pillar, the people who are implementing it, implementing the legislation, liaising with the individuals who are developing the culture, etc. So, as a practitioner, and I say again, practitioners are business people. They are running commercial organisations, and that has to be remembered. They have to make a decision whether they're going to get into it. Is it worth their while? Is it the size of the market? The costs associated? I know the fellow practitioners leaving the room, so obviously they've made a decision to leave the market. But the fact of the matter is, that was a bit unfair. But so what? But the reality is that's something that we have to decide and make a decision on. The first stage, though, is are we going to go to the time, the effort, and the cost in becoming a PIP? We have to train, we have to go on courses, they cost money. We have to register, that costs €1,500. We have to upskill or incur costs in terms of insurance, etc. So there's a lot of stuff that we have to do. We have to train our staff, we have to put in place infrastructure. So these are what firms like my own and the other large, certainly players are doing at the moment. We're resourcing our business to cope with the anticipated demand and to make sure that we can give what could be considered to be a professional service. Is there a large market out there? Well, the different estimates from anywhere between 10,000 to 40,000 potential cases. It's a market, and looking at this as a business that's going to be dealt with in the bulk of it in the next 5 years or so. And certainly, my own feeling of it is, and we can talk about it later during the question session, is that multi-banked individuals probably will be the best candidates for personal solvency arrangements. There is a big temptation on behalf of creditors who are the single largest creditors and single bank situations, for them to do deals outside this legislation in terms of saving professional fees, in terms of perhaps getting more favourable terms for them. So the PIA, I see, is going to be largely attractive to those who are mostly multi-banked individuals. Competition, when I say competition, who are going to act as PIPs? Well, solicitors, I say the Law Society ran a course last week. It was interesting, though. I was talking to somebody at lunchtime today, and they were saying that there were 70 people sat the course. At the beginning, all 70 put their hands up, they were going to become PIPs. At the end of it, it was about 7. Because they realised that this is a serious...
More money if you have more money.
Better buy a dinner dose, okay? And we'll come back to that later. But we will talk about fees, because we are prepared to talk about fees. And fees should be talked about. They're a very important issue. But, as you say, less... and anyway, I don't know how many solicitors are in the room, but how many solicitors do you see are good at totting up stuff unless it's the bill? So I'd say the world mostly the accountants. But anyway...
Just got me with 10 friends.
It's okay, yeah. It's okay, David. Okay. And at least 3... Yeah, no, it's fine. At least 3 UK specialist firms are going to enter the market that we're aware of. Accountants, mediators. I'm a mediator myself, and obviously I would agree that the skill sets that are going to be used are very similar to mediation. Mortgage brokers, a profession with no sense of irony, I think, if they're going to become PIPs. And then there's a number of bankers who are leaving the banking profession. Fee levels. To address it, they will be very competitive. They have to be competitive. But what that means for the PIP, that those who are going to become PIPs are going to have very streamlined procedures so that they can run it as a commercial concern. To become a PIP, you have to make an application to carry on a practice. So you have to be a solicitor, a barrister, qualified financial advisor, qualified accountant, or have another qualification as listed there. You'll also then have to pass an exam that shows your competency and that you fully understand the Act, the legislation, and the procedures required. And that's what a lot of individuals are going through at the moment. You have to demonstrate also that you have the organisational capability, the appropriate insurance, and apply in the proper way. And crucially also be tax compliant yourself. We don't want anybody getting embarrassed by the sheriff turning up. So very important that you comply. I'm not going to go through the application procedure, but there is a proper, fully thought out, comprehensive application procedure. The skill sets that the individual is going to require, well, you need to be competent and you need to have a good grasp of the legislation. And the reason I include this slide is it's not like dealing with a corporate. You have to be properly qualified and resourced and skilled up to be able to give this advice because of the implications of getting it wrong for the individual. So you have to have good background in the legislation, good tax skill sets, understanding of the various bank documentation. Crucially, and I'm glad someone mentioned earlier on, counselling skills. Counselling for the people that you're dealing with, they're at their wits' end. That's mentioned all the time. But you also have to be able to deal with it yourself as a practitioner. Your staff have to be able to deal with it. Because you're dealing with people, and the people in MABs would know about this. You're dealing with dealing with people at difficulty. It's very important that you don't bring that home yourself. So I'm training my staff on how to deal with people who are in difficult situations, so that for their own perspective. So counselling skills are very, very important. Share valuations, negotiation skills, persuasion skills, understanding of debt collection procedures, all the way down. Certainly if you're dealing with the consumer type cases, you want to understand social welfare, and then bankruptcy tourism. Because I firmly believe, and I note, and I understand completely what Chris was saying earlier on, but I do think that bankruptcy is one area that is going to increase, both in terms, and I've been saying for ages that there isn't that many people going to UK. There isn't, because why would there? This legislation is coming. But I do think there are reasons where people will seriously consider it, and I'll talk about that in a few minutes. Okay? I saw a piece of paper, I thought I was going over there. No, don't start now. Can we learn from our UK colleagues? Well, we have to learn from our UK colleagues as a PIP, because they have been doing this and have a legislative situation that is 30 years more advanced than ours. And what we've seen over there, much more mature market. And when they introduced their legislation, which is comparable to what we're introducing, there was a certain level of grandfathering in. We're not doing that, and it's only right that we're not doing it. And as Lorcan mentioned earlier on today, I heard Lorcan twice today speaking, so I'm glad to say it was a different speech, but he made a very good point in the first one, that we don't have the skill set. As Chris said, 35 people last year. Probably was it 15 the year before, 8 in 2008 I think it was. You know the figures better than I do. We don't have the skill set by and large. There may be one or two of us who think we do have the skill set, but the reality is the vast professional populace, be they solicitors, accountants, QFAs, don't have the skill set. The UK was slightly different, that when it was introduced in the late 80s or early mid to late 80s, it was largely business debt. Sole traders, their debt was the issue. It then moved on to consumer debt. We're different. We're dealing with a lot of property-related debt, so we're slightly different. The market in the UK now is the significant proportion of consumer debt, but certainly at the beginning it was more business-related debt. We'll see, I'd say, we completely skewed the opposite way here. In the early days, the UK regulations experienced a significant number of court challenges to clarify the law. I expect the same, and that's not because David's here, but I do expect there'll be a number of challenges. That has obviously, as items have been clarified, I have seen it. I expect that similarly here we'll see challenges to clarify parts of the law, but that will, like the UK, reduce as it matures. It also has been highly regulated from the off. ISI are going to highly regulate PIPs here, without a shadow of a doubt, which will lead to the fact, and I'm going to talk in the next slide about the number of PIPs. In the UK, there is a centralised voting. We're going to possibly see it here. We'd like some clarity. The establishment of protocols, I note what was published by the Central Bank last week, but I do think there needs to be a little bit more in terms to assist PIPs in the schemes that they're proposing to get a little bit more clarity. The reality is we need to know what is accepted and what is not accepted. We don't have real clarity in that regard if we're trying to formulate a scheme of arrangement. What we have seen is, though, as a result of the previous slide, what that led to in the UK was that there was a significant number of people became insolvency practitioners or regulated insolvency practitioners. They dipped their toe in the market. They realised the level of regulation they were under, the low level that there was in the fees, the costs associated, that if you weren't in this and in this properly, perhaps wasn't the business for you. And it led that a lot of the people who took up the role left it. I think there'll be a lot of people qualifying as PIPs, but I think they will not be in the market in 18 months' time. It will come down to a relatively small number of core firms who will do the majority of the work, because they'll have the systems, and systems will be crucial in this in place. Okay, because if you're going to deal with it you're going to have to do a volume, and you're going to have to have systems in place. So I expect that here. Next slide, I'm not going to go into it. It gives you an idea of the staffing levels based on the UK experience of what a PIP doing 100 cases a month will require. It gives you an idea of the body count that's required. Substantial enough. Software packages, a lot of software packages coming onto the market. Some very good, some maybe not so good. One thing is interesting is I don't know whether the software packages actually are developed to deal with the volume that certain practices may have, and those practices may need bespoke. Okay, that's a slide that both Lorcan and myself have used. I don't know who came up with it first, but I'm not going to give out if he doesn't either. But the key thing is, crucial to the whole situation is the role of the PIP. On to the advice that a PIP can give, and I'm going through this at a pace, but Section 52 of the Act states that on the completion of a PFS, the PIP shall advise the debtor of options for addressing his financial difficulties, their eligibility to enter into a DSA or a PIA, and their opinion whether it would be more appropriate to enter one or the other. But it doesn't give any further clarification as to what an options are. And this is where, should you not be going down this road and just dealing with the bank straight away? Because this is not going to work for you, okay? Should we be advising the individual that really bankruptcy is the option for you, but you can't go into bankruptcy here unless you come to see us, but you're here? Should you go into bankruptcy? Possibly. And there are reasons why individuals will go into bankruptcy. So the Act doesn't give clarity as to what that advice should be. But I do believe myself that in a lot of cases bankruptcy will be the option, based on the people that I'm seeing. That if you're an individual, someone asked a very good question earlier on about how it affects professions. But there's a lot of people who, based on what the standard of reasonable standing of livings are published, are earning no more than that as it is. They're in jobs, perhaps semi-state or civil service jobs, where the fact that they become, and we mentioned the guard, you can be a guard and become bankrupt. There was this idea that you couldn't. You have to explain the background to your difficulties. That it may be more suitable for them to go into bankruptcy and relieve them of the substantial pressure that they're under. So I think bankruptcy will be attractive to a number of people and will be the only option, and I think it could be a growth area. Why would a person go bankrupt? Well, there's a number of different reasons. Okay, say for example, and we'll take Paul. I'm just going to pick up Paul, and say Paul is married to Jane, just to make up a name. Okay, and Paul has financial debts. He's in difficulty, and he's married to a woman of independent means. And he figures, and they're looking at him, they're saying, Paul is going to be a long, long time recovering from these debts. But he could fight the good fight for a couple of years and ultimately still go into bankruptcy. But at the moment, Paul's wife, who has a good career, has earning potential, etc., and is not on those debts, could buy his share out of the family home at market value, because they believe they have a good home. It's going to increase in value 5 years down the road. Why wait? Buy his share out when it's more affordable to do it, when the equity that's in the property is less than it will be perhaps if the property recovers. People may do it to protect inheritance. I know one couple who went to the UK, one of the 90 that Chris referred to, because this was an only child. This lady was an only child. Her husband was had business debts of 3 million. They both had personally guaranteed them. Her parents were quite wealthy. They were in their early 60s. She went to the UK to become bankruptcy before she inherited. She took a gamble her parents were going to survive. Now, touch wood, they will. But the idea was, her parents changed the will. They set up a trust to protect her children. So she went to the UK. She's going through the procedure. The will will be changed in 3 or 4 years' time back to her. But the idea was that just in case anything happened and she inherited, that inheritance would be captured. So there's a number of different reasons and options why people would consider it. That's the question for the PIP. What options does he go into? The other thing is the timescales are quite tight. 70 days seems a lot of time, but it's not when you look at what has to be done. Time for the Insolvency Service to advise the PIP of the issuance of a protective certificate, excludable debtors of 21 days to decide if they're going to be treated, delay in agreeing the valuations of properties. You say Y, the bank say X, getting an independent person in. It all takes time. It eats into the time allowed. 10 minutes left. 14 days notice has been given to given for a creditors meeting, notifying the insolvency service. So it all adds up that the PIP really has 33 days to put together what could be a complex arrangement. We have ethical issues as well. And the PIP, is he advising, and it goes into what the ISO draft regulations, just say a health warning there, draft regulations. But acting for partners or acting for a husband and wife, really, should they have, it may be okay, as I say, if they have the same assets and liabilities, but if they have different financial circumstances, it may be a good time for the wife to disown her husband, or the husband disown the wife. It could be a happy or not so happy ending, but the reality is there could be an inherent conflict of interest in advising spouses. Can there be a question, can you be on the receivership panel of banks, a firm, and acting as a PIP? There is no conflict. Banks mightn't see it that way. They may decide that you can't ride two horses at the one time. We'll try. But the fact of the matter is that there may be, it seems to be an issue. The various case management issues, there's ways of opening the bank account. Just the practicality of opening a bank account. Sometimes it could take a couple of weeks to open a bank account. So this is where the firms, where the established firms, will have arrangements with their local banks that a bank account can be opened almost straight away. Because the minute you're appointed, you're in charge of the funds. And one of the key things that ISA are going to regulate the PIP on is the whole protection. We don't want any scandals about client accounts. We don't want any scandals about where funds are gone. So from day one, you have to have a bank account open and fully operational. So you have to have your systems in place. I do expect some of the issues that I think could be challenged. I think validity of meetings and quorums, no regulations agreed as yet, but in practice, certainly based on the corporate side, there will be heavy disputes and notice periods, valids of proxies, etc. There will be disputes, like every creditors meeting about a proxy. I expect them to be challenged, and I expect court challenges. I think this, and I do expect somebody to perhaps take a constitutional challenge on this, a connected person cannot vote. So you have a mother who gave a loan to a son or a daughter to borrow money to buy a house, and they're looking at doing a PIA. That mother or father or parents' funds or loan is not treated equally as a bank's debt or as other secured debt. I think that's unconstitutional. I suspect it's unconstitutional, and I suspect somebody at some stage will take a challenge. That's a personal opinion, but I do think it's an area that could be potentially issues with. As a PIP, I have to be considered negligence, so make sure my systems are in place. Looking at the UK, who sues for negligence? Traditionally speaking, creditors do not sue, but the debtors themselves do. That if it's not done right, again, it's interesting. So we'll have to have our engagement in place. But other potential pitfalls, the veto. It's been well spoken about. 3 million, again, I'm on record as saying I don't believe it's adequate. 3 million bought you a nice site in South County Dublin a couple of years ago. The reality that people are facing, 3 million, in my opinion, is not adequate. Identifying all creditors is an issue. Valuation of secured assets will be an issue. I think another issue is the whole issue of the connected parties. I reiterate that point there. I think that is going to be a massive issue. When I see the number of people who've got family debt and business debt or partners debt that they can't bring in. This is I've got three different legal opinions on this point here. You've got Noeline and Paul are in partnership. Noeline is a good mark. Paul is slightly more challenged. A bank goes to do a deal. Will it do a deal with Paul? In fear that if it does do a deal or PIA with him, are they compromising their ability to go after Noeline? I've got three different legal opinions on this. Okay, the general consensus is that the bank or the creditor, and I'm saying it's a bank, will be slow to do it. We haven't got a definitive opinion on it as at this stage. And I've only got a couple of slides left, and then I'll be gone or ready for questions. How the banks react to the legislation? Well, I'm not a banker. They are organising, or should be organising themselves to their federation. I expect protocols to be set. I think it'll be set relatively late in the day. We don't have them now. We're not aware of what they are. But there will have to be standard clauses to be incorporated into DSA and PSAs. I expect a cap in fees for practitioners. I think, given the veto, they will try and engage directly, particularly in the single bank situation, saving fees, to try and negotiate a longer scheme of arrangement, etc. And it remains to be seen if they establish a central voting company similar to TDX in the UK. I don't know if the market is big enough for them to do it. I've been blunt about it, but it would seem to me like something that should be seriously considered. Will it work? Ultimately, I think it will. Part of the reason I say that is because the Minister is on record as saying that if it doesn't, he's going to change it. I think it will have to change. Part of it will evolve. I think that's to be expected for something that's been brought to bear in a relatively short period. I think the market for PIPs will consolidate, and I think the banks will buy in, but it will take time. So going back to my 4 pillars, we have, I think, what's effective legislation. I hope going through the process we'll have effective practitioners. I believe that we have effective courts. It comes down to the culture and the culture of creditors. And I think the bank's attitude, and I say creditors, but I'm using the word banks there, will have to change for the new regime to work. They need to set tight and attainable standards, but I think, so that people are motivated and not crushed. But I think we will get there, but not immediately. Thank you.